The parole evidence rule prohibits the introduction of oral evidence to contradict the unambiguous terms of an integrated written contract. In Schinkel versus Maxi-Holding, the court considered when to admit oral evidence of contract changes anyway. Maxi-Holding was a Massachusetts holding company that held shares of lumber corporations. Its capital stock was owned by a Finnish company called Rake-Oy, which Mr. Cederberg controlled. In 1985, Cederberg hired Thomas Schinkel to manage Maxi-Holding. Schinkel's contract gave him the option to purchase shares of Maxi. In 1987, Schinkel and Maxi negotiated a second management contract. Schinkel hadn't yet exercised his option to purchase shares under the first contract. The parties orally agreed that because Schinkel's 1986 compensation wouldn't be known until later in 1987, he could defer payment for the shares and then pay the difference between $70,000 and the compensation he was owed. The written agreement that Schinkel signed stated that Schinkel would pay $70,000 for shares representing 10% of Maxi capital, half payable on signing and half 45 days later. In July, the parties estimated that Schinkel's compensation from 1986 would be $50,000. Schinkel paid Maxi $20,000 for his shares. The parties subsequently determined that Schinkel's precise compensation was $55,000. Maxi refunded Schinkel $5,000. Maxi then refused to issue Schinkel the shares he'd paid for. Schinkel sued Maxi-Holding for breach of contract and fraud. Maxi argued that the written contract from 1987 required Schinkel to pay $35,000 on signing and $35,000 45 days later. He hadn't done this, so Maxi had no duty to issue him the shares. It claimed that the oral agreement allowing Schinkel to pay the difference between $70,000 and his 1986 compensation didn't apply due to the parole evidence rule. The trial court held that the parole evidence rule applied and dismissed the case. Schinkel appealed to the Massachusetts Court of Appeals.